Welcome to today's podcast. I'm Catherine Magaña, a certified financial planner professional, and I'm here with Gita Nassiri, our special guest. She's an estate planning and business attorney, and she's here with us today from Capital Legacy Law. I've known you for many years, so welcome.
Yes.
And thank you for joining us today. We really appreciate you being here.
Thank you for having me.
Absolutely. And so today we wanted to talk to you about some tax or estate planning tips. I know last year in 2021, there was a lot of speculation, a lot of things on the table. Here we are in 2022 and just kind of want to talk about some estate planning tips for this year and things we should be thinking about. But before we get there, we wanted to learn a little bit about your background. If you can share with our listeners a little bit about who you are and how you ended up being an attorney.
Sure. It's very nice to be here, Catherine, and to spend some time with you and your audience and talk about estate planning, which I do day in and day out, and I love what I do. I have been doing it for 29 years now.
Wow, you look young.
Thank you. Thank you so much. I know, I can't believe it's been 29 years, but yes. And I actually started out as a business litigator and business and entertainment litigator. And I knew that I wanted to work more in the transactional area. And I was lucky enough to work with in a law firm where there was an attorney who did estate planning. And I have to say, in law school, the trusts and estates class, I did not enjoy.
Oh, really?
I didn't. but
you love it now, right?
I love it now. And and I learned from this attorney. I worked with him, and I took classes, and eventually got my master's in business taxation. So focused more on also the tax planning aspect of things, and I enjoy estate planning. It's really, I ended up doing what I really enjoy doing. I wake up in the morning, happy to go to work.
It's interesting you say that tax planning side or that background, because I know being a certified financial planner, I look at financial planning, tax planning, estate planning. I'm not an attorney, but definitely they all kind of go hand in hand, and they all integrate in some capacity. So having that knowledge or idea of knowing what's to come is important. So it sounds like you're very versed in everything that you do.
And it is a team. You and I have worked together, and it's not, I work and with my clients and their advisors, their financial planner and their tax person. I am a licensed CPA, but I don't prepare tax returns. I can give tax planning advice in an estate planning context, but it is you need the team of advisors to help you go through. There are things I don't know, and I rely on you really, and your clients and my clients rely on you to provide them with that financial expertise that I don't have, and there has to be that dynamic for it to work perfectly, I think.
Absolutely. I think there's definitely different specialties and areas that you focus on, and coming together and collaborating at the end of the day for your client and their best interests. So.
Absolutely.
So let's dig in a little bit about some of the 2022 kind of updates and things that have come down the line. Do you want to share some of the gift and estate tax exemption updates, and perhaps some of the gifting tax, or
Sure.
gifting for this year?
So for 2022, the exemption, federal gift, estate and gift tax exemption has gone up to $12,060,000, and it's a significant amount. But what does that mean? That means that during life and at death, you can give away up to that amount, and you wouldn't owe any federal estate and gift taxes. And for a married couple, that's potentially you can double that amount. So that's so there are no after that amount. Then, assuming you have an estate that's worth fair market value of that estate at death is worth $15 million, then the difference would be subject to potentially a 40% tax rate, state tax rate.
And so one of the things as we're planners or thinking of the future, I know in 2025, potentially it could revert back. So just something, I know anything can change between now and then. But,
Absolutely.
That's something
sometimes clients come to me and say, we want you to draft an estate plan for us that's going to save us taxes and estate taxes and income taxes and I cannot predict the future. None of us can.
But going from estimated 12 million to 5 million, that's a big change.
Yes, that's really reverting back to what it used to be, right? And that's how the law is written right now. So, but who knows? It could, yes, the way the law is written right now, as of January 1, 2026, the amount will, the exemption amount would go down to 5 million adjusted for inflation, right? But who knows what's going to happen in the interim, and maybe it won't. Maybe it depends on what the legislators decide. So we don't know.
So one of the things we hear, or I see a lot, is the annual gift tax exclusion. So that's definitely something that seems like are on the radar for a lot of families and people that like to give on an annual basis. Do you want to share a little bit about that?
Sure. In addition to that exemption we talked about, that $12,060,000 right now in 2022. In 2022, an individual can gift $16,000 to another individual without any gift tax implications, and no reporting requirements as well. And it doesn't reduce that exemption amount. And it's per donor, per donee. So potentially a married couple, could give double that amount to one person, and there's no gift tax exposure or reporting requirement. And there are certain exceptions that would then you can give more. For example, if you're gifting to for medical expenses or for educational purposes, that gift, if it's given directly to the for example, the university, then it could be a much higher amount, because these days education costs
are expensive.
It
has to go directly.
It would have to go directly. So yes, so there's that opportunity as well.
Nice. So one of the things that came up a lot last year was the step up in basis. I know that was a conversation. We heard it all year long.
Yes.
And it sounds like at the end of the day,
it didn't happen.
It didn't happen. So,
which is, yes, because that would have been a big change in the estate planning world, and it would have impacted everyone significantly, I think. Yeah. And no, there was no change.
No change. So just to go back, so it's either date of death or a 6-month alternative valuation.
Yes. So it's the rule is date of death. So when someone passes away, then the asset, the basis of that asset will step up to the date of death value. And so, for example, if someone passes away and gifts their home to their daughter, and at death that they bought the home for $200,000, at death that home is now worth $1 million. The step up in basis rules say that now, and I'm generalizing, the value of that home is the step up basis of that home is $1 million. So then daughter, after a few years, sells that home for $1.2 million. So the capital gains exposure is on that $200,000 difference, and which is a significant tax savings, right? So
do you think it's going to come back this year, or you don't know? I mean, it's just,
I don't know.
It just seems to me last year was such a big topic.
It was it was a big topic, and it was,
I think it got removed from,
and all of a sudden it was a big topic, and then it didn't happen. So I don't know if it's off the table completely or not, but it's something that, we should all be aware of and follow the discussion and see where it goes and if it continues.
So one of the things I wanted to share that I'm noticing for 2022 is the requirement of distribution. So the age limit is now age 72. And then
that's right, it's gone up.
Yeah, it did go up from 70 and a half to age 72. Oh. And then that's been a couple of years now. But what we're looking at is with the amount that's coming out, the IRS came out with a new table so that because life expectancies have changed. And so now it appears that our clients are needing to take a little bit less out now than they were in the past. So there's a different factor. So that's something that we've noticed this year for those that are taking requirement distributions, that potentially they may not have to take out as much because that was re-looked at for 2022. I guess another thing that comes up, what I could see occasionally is titling and properties. Do you want to share a little bit about that and your experience in dealing with estates and estate planning and how that works?
Sure, of course. I think titling is an important topic of conversation, especially when you are talking about funding a revocable trust, for example. Sometimes it's not just enough to set up your revocable trust, living trust. You have to fund the trust, meaning you have to now that you've created this living trust or revocable trust, you have to put the title of assets into the trust, and not every asset would need to go into the trust, but that's where that you have the consideration about what assets need to go and need to be titled in the name of the trust is important. Because if you don't do that, then if certain assets are outside of your trust, your revocable trust, then those assets could potentially be subject to would have to be transferred through your will and then potentially be subject to probate administration. And that's what the whole purpose of a revocable trust is.
I know that this probably doesn't happen to your clients, but I do see it occasionally. So for example, we have, I've looked at trust, and sometimes we've seen that people think, oh, I listed my assets,
Schedule A, right?
I have it listed in my trust. But then when you go to dig deeper and you realize, but your accounts aren't titled or your property's not titled, then there's that kind of, once again, making sure, even though it may be listed in the schedule, is it actually titled properly to avoid probate? So I think
that's right.
That's definitely a thing that I tend to see occasionally, is that making sure it's titled
it's
properly.
an important consideration, and it's something that we go for medical checkups, right? I think we need to do some financial planning checkups and estate planning checkups regularly too, because yes, for example, beneficiary designations. If you have to check and see with accounts, clients that have accounts with you,
are there any divorces or deaths?
Yes,
so there's
right.
something, a life event, or did you have or did you have minors that are now adults you want to put down, or there are a lot of life changes that happen. I think
and then sometimes we forget to look at our accounts and make sure that the beneficiaries, whether they're primary or contingent, and we should have a primary and a contingent, are the ones that we still want them to be the primary beneficiaries and the contingent beneficiaries of those accounts. And that's another way to, by the way, to avoid probate. It's not, revocable trusts are one way, but beneficiary designations are definitely another way of avoiding a probate process, the court process, right?
Absolutely.
So that's titling is important, and I think that's where the checkup and taking inventory and taking charge of your life and really looking into the assets you own and how you hold title and what you want to do with those assets and what your values are and how you want to protect yourself and your loved ones is important, and that's what estate planning is all about.
So one of the things that came to mind for me is occasionally I see people move either out of state or in state. And so that's another reason I think to review your estate plan and trust and everything, is because if you are moving states, you want to make sure that everything is updated properly.
Absolutely. I think that's another reason why you want to look at your estate planning documents, the documents you have in place, and make sure that they, we live in the United States of America, but each state has their own particular laws, and we have to make sure that our estate planning documents are compliant with that state's laws.
So you talked about loved ones. Obviously, estate planning is such a personal part of your life. I mean, obviously, and I can see even for myself doing a trust and getting our affairs in order. You're talking about the death, your spouse and you, and what are your wishes, and it's it's a little morbid, but I think I also feel better, like knowing that, gosh, for my kids, I have guardianship in place, or if something happens to, us financially, or, what both of us at the same time, who's in charge. And so even though it's when I have these discussions, I feel I kind of have this sense of peace of mind, knowing that if something did happen, that my family is protected, and I feel like I've done my duty, or what my husband and I've done our duty as a family to do what's right for them.
That's exactly right. You want to plan for the future so that you can enjoy the present. I think the best way to celebrate the love for your family and your loved ones, your children, is to make sure that they're taken care of, and that you've taken the steps to plan your estate. The worst estate planning is no estate planning, really, right? Yeah. And that's and you don't want that. I think with the pandemic and the COVID-19 pandemic that's been going on for the past 2 years, it's there's a heightened awareness of how life is finite and fragile, right? And by definition, if you're alive, at some point we're all going to pass away. So it really behooves every single one of us, responsible adults, to take care of having that conversation with ourselves and with our loved ones about what our wishes are, what our values are, what are taking inventory of our assets, and then how we'd like those assets transferred from one generation to the next, and what our wishes are. And it's not only assets I'm talking about, it's our values and how we want those transferred. And if there's the charitable intent, maybe that should be expressed. Or taking care of our minor children. What if the parents aren't there one day? Who's going to take care of the children? Yeah. The person of the children, and take care of them financially.
And then also you need to let that person know.
Right. And have that conversation as well. And if you can't make healthcare decisions for yourself, who would you want to make healthcare decisions for you? Right. And then what are your healthcare wishes?
Yeah. And it's interesting you say that, because my idea of my healthcare wishes were different before COVID. And then when COVID came along, it kind of changed a little bit, just because everything changed within the hospitals and the settings. And so it was just interesting. My idea of it changed a little bit. So, and that's okay too. You want to make sure you document your wishes. And
absolutely.
I think that's definitely important too. Like we talked about revisiting, and sometimes you have these things in place, but it is important to go back and make sure, is this still my wishes?
Wishes. And whatever your healthcare wishes are, that's personal, but that's something you want to convey to to your loved ones, and whoever you're naming as your agent in your healthcare directive, so that they know what your wish, are aware of your wishes, and you don't know how much that alleviates the burden that's on that agent to know that what your wishes are about, whether you I won't go into examples, but whatever those wishes are, they're expressed so that they know, okay, I am acting as the agent, but the burden isn't on me. These wishes,
you already know what they want.
I know what they want, and this is what they want. They've told me, so it's. I think you're doing yourself and the agent a huge favor by letting them having that conversation, letting them know exactly what your wishes are, and of course, the healthcare directive also names your conservator of the person, so that if you're incapacitated, you don't have to go through a conservatorship proceeding in probate court. So that's another reason you want that healthcare directive in place.
So what do you see as a misconception about when you're with estate planning? Is there anything that you come across that?
Misconception. Well, one thing that's what you just mentioned about you're realizing how important it is to have an estate plan, but one thing that comes to mind is estate planning shouldn't be a depressing process, right? I think it's you should be happy that you're planning your estate, because you're taking the steps to protect yourself, your family, your assets. So it's a positive process, and it's something that every one of us should be thinking about and doing. And then once it's done, check it off your to-do list. And once in a while, you need to go back and revisit and update, and obviously always talk to your advisors, your financial advisors, CPAs, and estate planning attorneys, and have those checkups over, regularly. If your wishes change, if your circumstances change, your reality changes, whatever the case may be, or the law changes, you may need to have updates. But it's part of just living is planning your estate.
So it's interesting as we deal with different levels of our lives, and maybe somebody that's younger or newlywed or just kind of getting started, they may kind of think, oh, maybe I don't need an estate planning attorney or trust or anything in that regard yet. But the reality is, you still need to have your wills, and you still need to have your powers of attorney. And so it is, I think, important to still start building that relationship, because you are, as you're getting more assets and accumulating wealth, and yet potentially you might need the full trust and some other things. So it sounds to me sometimes the idea of estate planning, you might think, oh, I have to have multi-million dollars, and, but the reality is there's a lot of aspects of estate planning that I think really benefit all different ages and areas of life.
Absolutely. I mean, if you don't have a will, then the state of California will dictate what's going to happen. Yeah. So at a minimum, you should have a will. And your powers of attorney, whether it's for financial decisions or healthcare decisions, that's something that is important, because if you can't make those decisions due to incapacity, then you have to, you don't want to go through you want to avoid a probate proceeding, and just designate an agent to act on your behalf. Someone obviously that you trust, and but there are many reasons for having an estate plan, even though you don't have millions and millions of dollars in assets.
Okay. So is there
minor children?
Yeah, absolutely. Yeah, you said there's so many more. There's more to it.
Yes.
I think when you realize, sometimes you think, okay, is it just because I have to have a house, or but the reality is there's a lot more to your personal estate plan and figuring out what you need.
At a minimum, though, you need to have those documents. Yes, when you have a home, then the conversation, the home or other significant assets, then you talk about, the conversation would then go more towards, do I also need other estate planning documents, like a living trust, revocable
and
trust.
Then it gets into even, like we talked about, minors or different ages. If you do leave assets, do you want them to get it at 18 years old, or do you want it to get at 25? I mean, you have a little more control over, I think, some of how things are handled.
Absolutely.
So I think there's a lot of flexibility.
Yes, and in a will, you can create what's called a testamentary trust in your will, and that would the will would say that at my death, if for example, minor children, if there are minor children, I want my assets, X asset going to this minor child, but if the child is underage, let's say 25, I'd like the asset to remain in trust until that age, and then you can put the parameters in there as to how you'd like the distributions to be made.
Nice. So is there anything else in 2022 that we should be thinking about, or anything else that we should on the horizon, or just as we're planning and kind of wrapping up?
First quarter, you want to think about planning and making sure, checking your estate planning documents and making sure they're up to date, and express your wishes. And new legislation and laws in 2022. Well, let's see. I'm not sure. I don't want to predict the future.
And that's the hard part. Even in our just every taxes and estate planning, and in my every industry, it's just there's so many moving parts, and there's things that they may come down the wire that we need to be aware of, but it's hard to plan, really know until it gets passed.
Of course, and there's one thing that it went into law last year, and it's Proposition 19, and it has to do with property taxes. But if someone is age 55 and above, they can potentially carry over and if they want to sell their in California sell their their home and buy another home, they can potentially transfer the taxable value of that home. Yes. Okay. So there's a huge potential for property tax savings there. And under new Proposition 19, you can actually do that 3 times during your lifetime. And it's been expanded to cover any property. Your home can be, you can live in Carlsbad, California, that's your home, and then move to up north to Los Gatos and buy a home there. It's all over California now. So there's that potential, yeah.
Oh, well, thank you. It's always good to know some new tips and things to think about.
Absolutely.
So Gita, thank you so much for joining us today
pleasure.
on our podcast. We appreciate your perspective on estate planning. We also want to thank our listeners for joining us today. And of course, we have a disclaimer. So this information being discussed is for informational purposes only. Please consult with your tax advisor, attorney, and financial advisor about your specific situations and recommendations. So once again, thanks, Gita, for being here.
Thank you.